Welcome to the Regulatory Transparency Project's fourth branch podcast series. All expressions of opinion are those of the speaker.
Rachel N. Morrison is an attorney and fellow at the Ethics and Public Policy Center. She directs the Ethics and Public Policy Center's HHS Accountability Project and previously served as attorney advisor and special assistant on the Equal Employment Opportunity Commission. Rachel, welcome.
Thanks for having me.
So the topic today is the Pregnant Workers Fairness Act, and this has been in the news a lot, but we want to just educate our audience. I guess just to begin, what is the Pregnant Workers Fairness Act?
The Pregnant Workers Fairness Act is a law that was passed in December of 2022. It was passed with bipartisan support. It was co-sponsored by Republicans and Democrats. It was supported by groups ranging from Planned Parenthood to the U.S. Conference of Catholic Bishops. And this law requires employers to provide reasonable accommodations to a qualified employee's known limitations related to pregnancy, childbirth, or related medical conditions, unless there's undue hardship on the conduct of the employer's business. And so this law really fills a gap in employment law by requiring pregnancy accommodations in the workplace. We have Title VII as amended by the Pregnancy Discrimination Act, which prohibits discrimination based on pregnancy, childbirth, or related medical conditions. But it does not require an accommodation, which would be more than just discrimination protections. And then we also have the Americans with Disabilities Act, which requires accommodations for qualifying disabilities. But pregnancy itself is not considered a disability. And so while some pregnancy-related medical conditions might be considered pregnancy or might be considered qualifying disabilities that would be covered and receive accommodation protections under the ADA, most of pregnancy conditions and pregnancy itself would not qualify and so is not entitled to those accommodation protections, which is why the Pregnant Workers Fairness Act receives such bipartisan support to support women and their children in the workplace.
That's great. And so has the Equal Employment Opportunity Commission, how has it either interpreted the Pregnant Workers Fairness Act, or alternatively, have they taken any action in the rulemaking space?
Yes. So Congress directed the EOC to issue regulations implementing the act, which they did. They proposed some regulations in August of last year, and these regulations were just finalized on April 19th. And so the EOC as a whole took a very broad view of what would be protected under the Pregnant Workers Fairness Act and the accommodations that would be required and the procedures as well. So digging in a little bit more to what that covers, when it comes to what would be considered pregnancy, childbirth, or related medical conditions that employers would be obligated to accommodate, the EOC interprets this as essentially anything related to reproduction. They cover things that are not medical conditions and are not related to pregnancy or childbirth, such as the use of birth control, menstruation, potential pregnancy, fertility treatments, abortion, as well as the normal conditions a woman could face during pregnancy. And so they really take an expansive view on what accommodations could be required under this law. You get this weird scenario where an employer could be found liable for not providing an accommodation for an employee who is not pregnant, and may never become pregnant under what they say is required to accommodate under this law, which is pretty ridiculous, but that's where the EOC is taking this.
And are there any religious liberty implications, of the EEOC's rule and how they interpret it?
Yes, there's a lot of religious liberty concerns and pro-life concerns. If employers are required to accommodate things such as abortion, contraception, fertility treatments such as IVF, potentially surrogacy or sterilization type procedures, all of those can have religious liberty and pro-life implications for employers who are religious organizations or pro-life groups who might not be religious themselves but are pro-life or a pro-life organization in their mission. And so there's a lot of there was a lot of pushback during the proposed rule stage. There was over 54,000 comments submitted opposing the EOC's abortion accommodation mandate, but the EOC went ahead and pushed this in their final rule regardless.
And to your knowledge, like what did the EEOC, say in response to opposition to their proposed rule?
They completely disregarded folks who were pointing out the textual interpretation of the rule itself, that abortion is not a medical condition. It's a medical procedure, not a medical condition, that it's anti-pregnancy and anti-childbirth because the goal is to end a pregnancy and it kills the child in the womb. But another important aspect of this is when the PWFA was being debated on the Senate floor, some concerns from some senators focused on whether the EOC could require abortion accommodations. And you have both Senators Bill Cassidy and Bob Casey, Republican and Democrat, talking up and down on the Senate floor that the EOC could not require abortion accommodations. This isn't an abortion accommodation. Abortion's not mentioned once in the law itself. It's a pro-mother, pro-baby, pro-worker act. And so this is something that's important. You have other senators talking about how this is just easy accommodations. It's not controversial. And if we're talking about abortion is probably one of the most controversial topics in the country, one of the most polarizing. But this law wasn't about abortion. It's not mentioned once at all. It was about helping women and their unborn children be able to maintain their jobs and work and provide support for them. But in the final rule, EOC mentions abortion almost 350 times, over 3 times more than they mentioned the term woman or women in the rule. And so this really shows the emphasis and the priority of the EOC. And so the EOC says that because their pregnancy discrimination guidance under Title VII says that abortion decisions could be protected as sex discrimination from sex discrimination under the Pregnancy Discrimination Act in Title VII, and 2 circuit court cases and 2 district court cases, one of which is unreported, also say that abortion decisions could be Title VII claims and protected under Title VII in the Pregnancy Discrimination Act, that this is established, that it was well known that this has been the position for nearly 45 years and something that the EOC has to implement, even though its pregnancy discrimination guidance is not binding, even though it's only a couple court cases that have held this. The Supreme Court's never held this. There's not even a majority of circuits that have held this. But the EOC says that it is the interpretation that they have to do. They completely ignore the legislative history of the PWFA and double down on abortion being required under the PWFA.
Is there some statutory text that the agency has referenced to support their interpretation under the Pregnant Workers Fairness Act?
As I mentioned, the PWFA does not mention abortion at all. What they do is they focus on the phrase pregnancy, childbirth, or related medical conditions. And because this is the same phrase that's used in Title VII, they're really looking to their interpretation of Title VII and a couple courts' interpretation of Title VII. And so you're several steps removed from the PWFA itself. You're not looking at the PWFA as a separate law from Title VII. You're not looking at the legislative history for the PWFA. you're looking at an interpretation of a phrase in a different law that's not part of the PWFA. And so the EEOC says that interpreting pregnancy, childbirth, or related medical conditions to include abortion is consistent with the plain language of the statute, congressional intent, and federal court's interpretation of the statutory text. So they completely ignore the statutory textual arguments as far as why the PWFA, even if Title VII in the PDA covers abortion, why the PWFA does not or should not. They suggest that to interpret it otherwise would be problematic, that it could raise major question if they don't interpret it. Many folks in their comments had suggested that it's a major question whether abortion accommodations are required of employers across the country, which I think it is correct that the Congress imposed an abortion accommodation mandate without even mentioning abortion once, especially for a bipartisan law and something that was supported from folks across the ideological and political spectrums. And so the EOC completely ignores all of that and just says that they're interpreting it consistent with something that's been established for nearly 45 years. For folks who want to know a little bit more about that, I'd like to direct you to Commissioner Andrea Lucas's statement concerning her dissenting vote on the final rule. She goes through the EOC's claims of interpretation and reliance on statutory canons of interpretation and does a great job thoroughly rebutting that.
And so you referenced a vote, the EEOC's vote on the final rule. Do you happen to know what the vote was in terms of numerically? So there's 5 members, I think, on the EEOC.
Yes. Yes. So there are 5 commissioners. There's 3 Democrat appointed commissioners and 2 Republican commissioners. And the vote was 3-2 along party lines.
Okay. And you had previously referenced the Notice of Proposed Rulemaking, otherwise known as an NPRM. Has this rule been published? And if so, when is its effective date? So is it effective right now as we speak on May 30th?
So the PWFA went into effect 6 months after it was finalized, so June of last year. So the law itself is in effect. The EOC's final rule goes into effect 60 days after it was published, so mid-June. Okay.
And is there any litigation? You've brought up some, the EEOC's final rule, and during the comment, different interpretations, of course, of the underlying statutory text. Are there any lawsuits or any litigation surrounding this final rule?
Yes, so there are 3 lawsuits currently that I'm aware of. The first is a lawsuit from the state of Texas. This lawsuit's actually against the PWFA itself, and it predates the final rule, but it is a challenge to the PWFA under the quorum clause of the Constitution. Now, I was not very familiar with the quorum clause before this lawsuit, but it's a provision that requires a majority of the House or Senate members to be physically present to constitute a necessary quorum in order to pass legislation. And when the House passed the PWFA, this was still during COVID and when a lot of folks were working remote. And so the House only had 205 members vote in person. The rest voted by proxy. And so this fell short of the 218 members to create a quorum in the House. And so a district court permanently enjoined enforcement of the PWFA by the EOC or the Department of Justice as to the state of Texas as an employer itself. The EOC has appealed this decision to the Fifth Circuit. And so this is a challenge to the law itself. And it will be interesting to see what happens there because this is a challenge to the underlying statutory basis of the law. Any employer who is hit with a PWFA discrimination lawsuit could also raise the quorum clause as a defense. And so until this issue is litigated, decided by either a majority of the circuits or the Supreme Courts, I suspect that this is going to keep popping up, or any employer who's trying to defend a PWFA lawsuit would be silly not to bring this up if their circuit hasn't already decided this issue in application to the Quorum Clause. So while this doesn't challenge the rule itself, it challenges the PWFA, the underlying statute, and it could have major implications, because if the statute wasn't legally passed, if it's unconstitutional, then of course any of the rules would fall as well. So looking at challenges to the final rules itself, there was a lawsuit led by Tennessee and Arkansas of a coalition of 17 states to challenge the final rule. They focused primarily on the abortion accommodation mandate. They argued that the rule violated the Administrative Procedures Act and the Constitution, that interpreting pregnancy, childbirth, or related medical conditions to require abortion accommodations was arbitrary and capricious, that the EOC didn't properly account for federalism concerns, state sovereignty issues, First Amendment concerns, as far as this abortion accommodation mandate. And so they sought a judgment that the PWFA doesn't authorize the EOC to impose the abortion accommodation mandate. And another claim they brought up in their lawsuit was to the EOC status as an independent federal agency. And so they argued that the independent structure violates Article 2 in the separation of powers. And so this is another claim that, again, is broader than the rule itself, and it challenges the EOC as an agency in the way it is structured as an independent agency. And so it'll be interesting to see what happens there. And if that claim is successful, it could have major implications for the EOC and any rulemaking and enforcement of the EOC going forward. The district court in Arkansas is going to hear oral argument the first week of June. And so we'll be keeping a close eye on that case. And then the final case is a lawsuit by the U.S. Conference of Catholic Bishops, along with the Catholic University of America and 2 Catholic dioceses. It was filed May 22nd, and it challenged the PWFA, raising religious liberty concerns as far as, especially related to the abortion accommodation mandate, and the impact on religious employers of having to provide employees abortion accommodations that violate their religious beliefs. And this was filed in Louisiana. In its final rule, the EOC showed a disregard for folks who raised religious concerns in the comments. They were very dismissive of the real concerns that folks had as far as providing accommodations that violate their religious beliefs of the religious organization. They pointed folks to possible religious defenses and exceptions under law, such as the PWFA's incorporation of Title VII's religious organization exemption, the Religious Freedom Restoration Act, and protections under the First Amendment. They refused to opine on any fact-specific scenarios, and instead said that all these determinations were case by case and something that needed to be determined in the future, which does not provide any sort of consolation or protection or anything that these religious organizations are going to be able to rely on in order to make employment decisions and whether they can operate their business according to their religious beliefs and not have to provide accommodations that violate their religious beliefs. Regarding Title VII's religious organization exemption, EOC took a very narrow view of what this exemption applies to. They said essentially that it only applies to claims of religious discrimination. And then they even suggested that it only applies to claims related to hiring or firing, that it doesn't apply to claims of other terms or benefits of employment. The Title VII religious organization exemption says this subchapter shall not apply to a religious organization with respect to the employment of an individual of a particular religion. And so the phrase, "this subchapter shall not apply," refers to the entirety of Title VII. And so this is, again, a very non-textual reading that the EOC is taking to try to minimize protections for religious organizations. And the fact that the PWFA incorporates Title VII's religious organization exemption suggests that it would apply to claims broader than religious discrimination and apply to terms and benefits, including accommodation claims. But if the EOC interpretation is correct, that it only applies to religious discrimination claims or only applies to hiring or firing claims, then the incorporation would be pointless and provide zero protections when we're talking about pregnancy accommodations that have nothing to do with religious discrimination or hiring and firing claims. And so that's I think, an apt example of how the EOC just completely disregarded the religious liberty concerns and is trying to minimize those protections. And so any of these case-by-case determinations in the future, it's pretty clear where the EOC is going to fall on those lines, even if they don't want to say so explicitly in their final rule.
And could you give me an example just in general of like what, I know you've mentioned, accommodations, but could you just give me an example of like what a pregnancy accommodation would be that an employer would, generally have to offer an employee, a woman who is in fact pregnant?
Yeah, so I think general accommodations or things that would be helpful for someone with pregnancy could be a stool to sit on if they have to stand, water, additional bathroom breaks, light duty. So if an employee has to lift heavy packages, not lifting as heavy packages as well. And so these are just common sense type accommodations to accommodate for the physical experience a woman undergoes during pregnancy. It's going to look different, obviously, for each woman, since each pregnancy is different and affects women differently. It'll look different probably at different stages of the pregnancy as the pregnancy progresses. And again, there's not one accommodation that has to be required for every employee in every single circumstance for every employer. The accommodation has to be reasonable and it can't pose an undue hardship. So you could have different fact scenarios where maybe a woman sitting on a stool for one employer makes sense, but maybe for another employer, it would be an undue hardship. Or it wouldn't be reasonable because of the type of the job itself. And so a lot of these situations are very fact specific and something that might be true in a lot of cases, but might not be true in every case. And so, but having that protection for those reasonable accommodations, it's sad to hear that a number of pregnant women have been denied even just an additional bathroom break or water or things that are not an undue hardship on the employer and something that would ease their ability to work and work during their pregnancy. And so overall, this law does a really great thing in providing those accommodations and those protections for pregnant women. But the EOC has interpreted this so broadly that they're making what was a bipartisan non-controversial law of providing these pregnancy accommodations into something that's an abortion accommodation mandate. And at the end of the day, that's something that's going to hurt women. It's going to hurt employers, and it's going to make it much more difficult to provide any kinds of protections for pregnancy going forward.
Well, Rachel Morrison, thank you so much for providing this explanation of the Pregnant Workers Fairness Act and also the rules that have come out of the Equal Employment Opportunity Commission. Thank you for your time.
Thanks.
On behalf of the Federalist Society's Regulatory Transparency Project, thanks for tuning in to the Fourth Branch podcast. To catch every new episode when it's released, you can subscribe on Apple Podcasts, Google Play, and Spreaker. For the latest from RTP, please visit our website at regproject.org. That's regproject.org.
This has been a FedSoc audio production.